And we're live.
Good evening, everyone, and welcome to our last mini-series, our last webinar of our 4-part mini-series on estate planning documents. Tonight, we're talking about wills. So we'll wait just a few more moments for any last stragglers who are joining. Lots to go over today. Just like previous weeks, we have some polls and some handouts, so do keep an eye out for those. Jenny will release those throughout the presentation. And then we'll save questions at the end, but you can, of course, add any questions that you have into the chat. So we're talking today all about wills. But before we get into that, just a little background about our firm. We focus primarily on estate planning, probate, and trust administration. And today, talking about wills, that falls into estate planning. We're going to talk a lot about what wills do. We're going to talk about the probate process, how to form a will in Florida, how to create a valid will, how to revoke it, terminate it, all kinds of things. So at the very, very start, I wanted to contrast a last will and testament, or what I'm just going to call a will for this presentation, with a living will. Sometimes these get a little confused, or people use them interchangeably, or they think that they're the same thing. So what we're talking about tonight is a last will and testament versus a living will, which is a document where you specify under what circumstances, if at all, you would want to be removed from life support. So a little bit different there. Sometimes people also confuse a living will with a DNR, or a do not resuscitate, which is something else as well. You know, do not resuscitate is saying don't resuscitate me, don't touch me, versus a living will, which is all about life support. So when we talk about a will, what is a will? A will is a legal document that specifies where you want to leave your property to after you pass away. This will is going to name a personal representative, beneficiaries, guardians for minor children. We'll flesh that out a little bit more in a few slides and talk about who the players are in a will. It's important to note, and this is probably something that we get asked all the time, and in my opinion, this is one of the biggest misconceptions or misunderstandings about wills, is that wills only control the probate process. And we're going to dive a lot deeper into that. Wills don't control property or assets that pass automatically to a beneficiary outside of the probate process. So that's a really important distinction to make. Wills only control property that's going through the probate court process. Who are the players? So we have the testator or testatrix. This is the person who's signing the will, who's making the will. So testator is for a male signer. Testatrix is kind of an antiquated term, but some firms use it still. It's how do you refer to a female person who's making a will? The personal representative, sometimes this is called an executor or administrator in other states. In Florida, they're called the personal representative. This is the person who is administering the estate. This is the person who's signing paperwork with the judge, carrying on that probate administration, and wrapping up the final affairs of the decedent, who I should have added here. The decedent is the person who passed away. That person is going to be referred to as the decedent. They are a testator when they make the will, and then after they pass away, they become the decedent. Beneficiaries in the will, this is who inherits the property. There are different kinds of beneficiaries. So I have 3 examples here: a specific beneficiary, or a specific devisee, or a specific bequest. This is where the will leaves something specific to a specific beneficiary. So, for example, I leave my condo to so-and-so. That's a specific devise. You're leaving a specific piece of property to someone under your will. A residuary beneficiary this is where things are not specifically devised. If the will just says I leave all of the residue of my estate to Jenny, then Jenny is a residuary beneficiary, and Jenny is the beneficiary of whatever is passing through probate under my will. Contingent beneficiaries are like backup beneficiaries. So oftentimes a will say, I leave my condo to Jenny. However, if she predeceases me, then I leave my condo to so-and-so. That so-and-so person would be a contingent beneficiary. They can be, you can name contingent beneficiaries for specific devises that you're leaving, or contingent beneficiaries for the residuary, for everything that you're leaving under the will. Last, guardians for minor children. So if you have minor children, your will is where you can name guardians for them. If something, God forbid, happens to you and your minor children are still under the age of 18 at the time, your guardian that you nominate in the will is who's going to take custody of that minor child and be taking care of them until they turn 18 years old. So when we talk about a will and the fact that the will only controls property that has to pass through probate, let's talk a little bit more about what probate is and get a better understanding of that. So probate is the court process that is sometimes necessary to transfer someone's property to their beneficiaries after they pass away. It's not always necessary. It depends on how assets are titled and whether they name beneficiaries and things like that. But when probate is necessary, the process can oftentimes be very time consuming, it's expensive, and you are subjecting your beneficiaries to having to navigate the court process when they are already experiencing a lot of grief. So it can be really, really heavy, emotionally very taxing, and something that you can certainly avoid and that you want to avoid, whether that's through a revocable trust or some other kind of beneficiary designation or something like that. When we talk about probate administrations, you'll see that they are referred to as either intestate or testate. And what this means is, or what this comes down to, is whether the probate administration is subject to a will. When the person who passed away didn't leave a will and they have property that needs to go through probate, that's called an intestate administration. And without a valid will to admit to the probate court, that person's beneficiaries are determined under Florida law. So the Florida statute says after someone passes away, this is the hierarchy or the distribution scheme that this person's property is going to go to. So the Florida legislature came up with this distribution scheme on who they presumed a person would likely leave their property to, but it doesn't always align with someone's intent, especially when you have complicated and different family dynamics. Sometimes who the statute makes as your beneficiaries is not who you would have left your property to if you had a will. So that's where wills become really important to have, even though they don't keep you out of the probate process, they only control it. Sometimes having a will can be a way to make sure that your property does ultimately go to who you want it to go to. On the other hand, testate estates, that's when you have a valid will and there's been a properly executed will being admitted to probate, and the beneficiaries of that probate administration are outlined right there in the will. So we talked a little bit before about how probate is sometimes necessary, not always. It depends on how things are titled and beneficiary designations. We're going to talk a little bit more about that right now. So assets that don't pass through probate are assets that are perhaps jointly owned with someone else with rights of survivorship, for example. So a piece of property, if you own it with someone else with rights of survivorship, that means that if something happens to you, if you pass away, that property goes 100% to the other surviving co-owner outside of probate. It happens by operation of law. That means it just goes directly to the other co-owner. Assets that have a designated beneficiary, such as TOD, POD, or ITF, these are indications that a bank account, for example, has a beneficiary, or it will pass automatically to the person named to receive it upon the death of the account owner. TOD, transfer on death, POD, payable on death, or ITF, in trust for, all indicate that that account has a designated beneficiary on it, and that upon the death of the account owner, that account is going to go straight to that designated beneficiary. Assets that are titled in a revocable trust don't pass through probate. They're going to pass to the beneficiaries pursuant to the terms of the trust outside of the probate process. If not mentioned above, most other assets will pass through probate. Generally, things go through probate when they are individually held and they don't have some way of going to the beneficiary automatically, whether it's, again, by joint ownership or beneficiary designation. How to create a valid will in Florida. So a few things here. One, you have to be at least 18 years old to make a will in Florida. You have to be of legal age to legally contract. Next, you have to have testamentary capacity and sound mind. Florida case law has defined what it means to have testamentary capacity, and generally speaking, it means that you understand the nature of your estate, you understand your property and what you have, and you understand who you're leaving your property to, the significance of that. That is a legal term and it is legally defined, so it's very specific. Formalities. So when we talk about will formalities, that's really how you have to sign the will to make sure that it's valid. So some of the will formalities, as we refer to them, are that you have to sign your will at the end of the document. So it has to be signed by the testator or testatrix at the end, not in the middle or the first page. It has to be signed at the very end. It also has to be witnessed by two people who sign both in your presence and in the presence of each other. So there is a presence requirement when you sign a will. Best practice is to have everybody in the room at the same time and nobody leaves until everybody has signed where they need to. Oftentimes you'll see a will with something called a self-proving affidavit. This is the notary section of the will. Having the will notarized is not required for it to be valid. It does make the will easier to admit to probate court if it has a self-proving affidavit. But if you have a will without this notary section and you have a will that is otherwise properly signed by the person at the end and properly witnessed, it is a valid will. You'll just have to take a few more steps to admit it to probate court. You'll have to take testimony from the witnesses who can attest to the fact that they signed in the presence of each other, they signed in the presence of the testator. So while having the self-proving affidavit doesn't, or not having it doesn't invalidate the will, it does make it a little bit easier to admit to probate court. I wanted to talk a little bit about no contest clauses. So no contest clauses, this is something that you'll find in a will that says if a beneficiary of mine challenges my will or brings a will contest in court, then they're cut out or I'm reducing their inheritance to $1 or something like that. No contest clauses are, while they are valid in some other states, they are not invalid or enforceable in Florida. So if you make a will in Florida that says, if my beneficiary challenges this will, I'm cutting them out, it is not enforceable. Maybe in other states, but not in Florida. Types of wills. So just going to talk about this very generally. A simple will is a will that says, I'm the testator, this is my personal representative, and here are my beneficiaries. Kind of straightforward, leaves the probate assets outright to those beneficiaries. Versus a pour-over will. A pour-over will is often created in conjunction with a revocable trust. So when you have a revocable trust and you're taking steps to properly fund that trust, you're transferring property into it, you're retitling assets, you're doing that for the purpose of having all of your property flow through the trust and not subjecting anything to the probate process. However, having a pour-over will can be helpful because if something has to go through probate for whatever reason, or maybe you meant to put it into the trust and it slipped through the cracks, or you didn't get around to it and it has to go through probate, your pour over will names your revocable trust as the beneficiary. So it's called pour over because it says whatever property has to go through the probate process, just pour it over into my revocable trust at the end. So pour over wills are oftentimes made in conjunction with a trust and they work hand in hand, although sometimes they will never have to be used if everything is already properly titled in the trust. Holographic wills are handwritten wills. They are recognized in other jurisdictions, not in Florida. So holographic wills are handwritten wills that don't have to be witnessed. I will bring up kind of an exception to this in a few minutes. I think now is a good time for Jenny to introduce our first poll, which is going to be a true or false question. If I have a will, then my assets, so true, false. If I have a will, then my assets don't need to go through the probate process after I die. True or false? If I have a will, then my assets don't need to go through the probate process after I die. We have a few answers coming in. So the answer to this is false. If you have a will, that doesn't mean that your assets don't go through probate. Having a will only controls the probate process. So this comes up a lot when we meet with clients. Someone's passed away and they come in with the will and they say, well, why do I need probate? I have the copy of their will. And it's the truth of that is the will's only controlling what happens or who that probate asset goes to in a probate administration. I'm going to jump back to holographic will real quick. So a holographic will is a handwritten will. In Florida, if you handwrite your will, it doesn't have to be typed, but if you handwrite your will in your own handwriting on paper and you execute that will with the will formalities, so going back, so if you sign it at the end and you have two people witness it in your presence and in the presence of each other, that is a valid will. So there's kind of a little asterisk there with holographic will. If that holographic handwritten will otherwise meets will formalities, then it can be a valid will in Florida. Amending and revoking wills. So we'll talk a little bit about codicils and how you can make a new will and how you can revoke it. Codicils are an amendment to a will. If you make a codicil to your will, either amending a part of it or maybe taking a certain part out or revoking a certain part, that codicil has to be executed with the same will formalities that you need to do when you create a will. So it has to be signed by you at the end, has to be witnessed by two people. Again, doesn't need to be notarized to be valid, but having that self-proving affidavit does make it easier to admit to the probate court. If you've already done a will and then you subsequently create a new will, you can put language in that new will saying that you revoke that prior will that you made, or you revoke all previously executed wills made by you. So that's one way to revoke one. You can just create a new will that supersedes the old one that you made. You can also revoke a will by physical act with an intent to revoke. So that second part is important. Both parts are important. It's kind of like a two-part test. So if you take your will and you tear it up and you burn it, destroy it, whatever, but you don't have the intent to revoke it, then you may not have revoked it. So in addition to that physical act of destroying it, you need to have the requisite mental intent to revoke that will by that act of revocation, that physical act. Jenny, why don't we introduce our other poll here as well? This next one is a multiple choice question. All of the following are required to create a valid will in Florida except, so our choices are 1, signed by the testator or testatrix, 2, notarized by a notary public, 3, witnessed by 2 people, and 4, in writing. This one's a little bit easy because I just touched on this one a few minutes ago. So the answer to this one is notarized by a notary public. As we already mentioned, it is not required to have your will notarized to make it valid. It just makes it easier to admit to court. So this slide here, where should I keep my will? I get this question a lot. We get this question a lot when we meet with clients, and there's no definite answer to this. It really depends. Certainly you want to keep it somewhere safe, because if something happens to you and you have property that needs to go through probate, the court is going to want and require the original copy of that will. So they want the one signed by you in ink that you signed in the room with your witnesses and everybody. So wherever you keep that, it needs to be somewhere safe. Sometimes clients will leave their original will at their attorney's office. Sometimes attorneys hold on to the original wills. They keep them in a safe that they have. Sometimes clients will take them home with them. If you do take your will home with you, make sure that you're keeping it somewhere safe. Make sure that the person that you've named as your personal representative knows that you have a will and knows where you've kept it. I don't typically recommend giving out copies of your estate planning documents to the people that you've named, with the exception of your healthcare surrogate for medical emergencies. But generally speaking, I recommend you just tell the person that you've named where they could find it, or give them your attorney's information so that they know who to reach out to if something happens. But you certainly want to keep it somewhere safe. And then safe deposit boxes here. Sometimes people leave their wills in safe deposit boxes. I generally don't recommend leaving it in a safe deposit box. Sometimes banks can be very difficult when it comes to accessing a safe deposit box after someone passes away. They can be a little bit of a pain. So if you can avoid leaving it in a safe deposit box, I do recommend it. I recommend getting rid of your safe deposit box. But there is a Florida statute that says that a person, a certain list of people, can look into your safe deposit box if they're looking for a will. They can't take anything out, but the statute does allow them to go in and look for an original will in your safe deposit box without a court order. Our last slide here, this is our information. So if you guys have any questions, please feel free to put them in the chat. I hope you guys learned a lot. Also, Jenny, if you would release the handout, I drafted 2 sample wills for you to take a look at. I drafted a simple will. That's the basic will that we talked about, and then a pour-over will where you'll see that there's a trust involved. Our characters here for the simple will and the pour-over will are the Harry Potter characters. So you're going to see Harry Potter and Hermione and Ron and everybody in there, and you can take a look at those. Both wills include beneficiaries and personal representatives and a section for guardians of minor children. So thank you for joining us on our last installment of our 4-part mini-series on wills. I hope you learned a lot. I hope this helped clear some confusion or misconceptions that you maybe had about wills. If you have any other questions on wills or any of the documents that we talked about during this mini-series, you can call us, send us an email, visit our website. We're happy to answer any questions that you have or go over any of the documents that we talked about. I want to thank you for joining us and being a part of this mini-series. If you have any suggestions on information that you'd like us to touch upon, please do reach out to us, and we'd be happy to come up with some material and some other webinars to answer your questions. I hope you all enjoy the rest of your evening. Thank you again so much, and I look forward to seeing you again on another video series and webinar series very soon. Thank you so much.